Hi everybody, welcome to the Foreign Correspondent Club of Japan for a new press conference. My name is Karine Nishimura, working with French Radio France and Libération newspaper, and also member of the PAC committee with organizing press conferences here in this club. We have people attending online, so I encourage them to send questions. And of course, we will also have questions in the room. Today's topic is hostage justice system. It's not the first one press conference on this matter, and it will not be the last one, because this is a very important matter here in Japan, and we are happy to have today a very famous attorney at law, Mr. Takashi Takano, as well as a filmmaker and nurse, Tomoya Asanuma, and they will explain us a new case on this matter, and we will have opportunity to ask many questions. So please listen to them. First of all, Mr. Takano, and after that we will have a question and answer. Please, Mr. Takano, the floor is yours.
Yes, thank you. First of all, I thank Ms. Karin Nishimura, Saikawa-san, and all the members of the FCCJ, and of course the special support from Mary Joyce. Thank you very much. Well, today we're going to announce that we started the new litigation against Japanese government in order to stop so-called hostage justice. First of all, I'd like to make some comment about the foreign system in comparison with the Japanese system. Famous King of Pop, Michael Jackson, was issued arrest warrant, but he was not actually taken to the custody. He simply reported to the court and released on bail, file post on the $3 million US, and he could continue to be pop star. And finally, he got acquitted by the jury trial. And Miss Men Wonso, she was the CFO and chairperson of the Huawei, was arrested in Canada following the extradition request by the United States. She was arrested, but then she was released on bail too, and she could continue to be a CFO and chairperson of the big global IT company. And finally, the charge was dropped. Recently, Mr. Ippei, Miss Ippei Mizuhara, interpreter of the Shohei Ohtani, was arrested. But within a couple of hours, he was released on bail. And during the 6 months period of a negotiation between his lawyer and prosecutor, finally reached to the agreement, guilty plea, and he would go to prison for 4 years and 9 months. Well, this is a very normal practice about pretrial detention system in US or common law countries. What if they had been arrested in this country, Japan? Well, you know, the king of pop or CFO or famous professional baseball player's interpreter was detained more than several months, even more than 1 year, and during which time they lost everything. They lost their property, their liberty, and they cannot contact with family, they lost everything. Even their trial is not started. And a long time the trial, they lost everything. Well, this is, Japanese practice. It is going on right now. And, in a sense, Japanese criminal justice timeline is not going forward. It is going backward. Punishment first, then trial, finally the crime, if there was a crime. And in other words, there is no right to be treated innocent until proven guilty. So this is the practice of Japanese hostage justice. And, international society criticizes this way of criminal justice is medieval way of justice. We started new litigation against Japanese government. We representing 4 clients, 4 plaintiffs, including Mr. Asanuma, and 3 other former detainees, filing the damage suit against Japanese government based on the unconstitutionality and violation of international human rights treaty by this hostage justice practice. We argue, among other things, the legislature which make it possible this hostage justice is unconstitutional. The languages of the statute itself is unconstitutional. For instance, the Article 60, Section 2 of the Criminal Procedure Code in this country provides that if there is a reasonable ground of hampering evidence on the part of the suspects or accused, he or she would be detained. Or Article 89, Section 4 has the same languages. If the court find out the reasonable ground of hampering evidence by the defendant cannot be released on bail. This vague language is the core base for creating this hostage justice. So we argue that this provision itself, this legislature itself, is unconstitutional, as well as the violation of the International Human Rights Committee treaty. And another point we would make is the procedure itself. How Japanese judges or court decide the detention order. It is very simple. They simply based on the documents provided by the prosecution side. It is a simple documents of the investigation, and defense side cannot access these documents, which means that the Japanese judges and prosecutors share some secrecy of the documents, and the judge decide based on these secret documents to detain the accused and deny the bail. So we believe this is unfair, and this legislation itself is unconstitutional, and it is under the standard of the international fair trial or fair detention system. So we argue basically these 2 points. First of all, the vagueness of the languages of the requirement for detention. The second is the procedure itself is very unfair. In the US and the other common law countries, this detention decision is based on hearing. in open court, the prosecution side can argue the necessity of the detention, and defense side can make counter argument, even produce some evidence in open court. But in this country, all the procedure of the detention order is made in secrecy. This is very unfair. So, we argue this kind of point, and we're representing 4 former detainees, including Mr. Asanuma. Okay, so now I, give Mr. Asanuma to comment his.
後でたくさんの質問が来ると思いますので、
Yes.
はい。浅沼さんどうぞ。はい。
皆さんはじめまして。原告の一人の浅沼智也と申します。
So hello everybody, thank you for today. I am one of the plaintiffs in this case. My name is Tomoya Asanuma.
僕は2024年3月14日、強制わいせつ罪で青森警察に突然逮捕。4月4日、暴行罪で起訴されました。
I was suddenly arrested by the Aomori Prefectural Police on March the 14th, 2024 for indecent assault, and I was charged on April the 4th, 2024 with an assault charge.
起訴後、計5回保釈申請をしましたが、一貫して否認を続けていたこともあり、4回、罪証隠滅の恐れ、逃亡のリスクを理由に却下をされ、約3ヶ月半、身体拘束をされていました。
After the indictment, I applied for bail on a total of 5 occasions, but since I was consistently denying any guilt in relation to the charges, I was denied 4 times these bail applications on the grounds of potential fear of destruction of evidence and risk of flight, and I was held in custody for approximately 3.5 months.
しかし、事件発生日の2023年2月15日から逮捕日まで、約1年以上経過していることや、逮捕時に家宅捜索を受けてもなお、何を罪証隠滅するのか却下理由の中に具体的な内容はありませんでした。
However, more than a year passed between the date of the incident, February 15, 2023, and the date of my arrest. Further, my house was also searched at the time of the arrest, yet no specifics were given within the reasons for denial of my request for bail as to what kind of evidence I could possibly destroy.
また、身元保証人がいることや、社会的地位の高い看護師の仕事をしている中で、なぜ逃亡のリスクが高いと判断をされたのか不思議でなりませんでした。
Also, as I both had a guarantor and I was employed in the nursing profession, an occupation with a highly regarded social status, I could not help wonder why it was that they would see that a potential risk of flight was considered to be so high.
また、2回目の保釈申請の際には、許可をされやすいように、携帯所持禁止、被害者のいる青森県から遠く離れた他県にある実家への在住、被害者及び事件関係者との接触禁止を条件に申請をしていましたが、具体的な却下理由は明記されないまま、罪証隠滅の恐れ、逃亡のリスクを理由に却下されました。
In addition, on the time of my second application for bail, in order to make this easier to be granted, I applied for bail with the conditions of no possession of a mobile telephone, living at my family home in a prefecture located far from the victim's home in Aomori Prefecture, and having no contact with the victim or anyone else involved in the case. However, even despite this, the court rejected my application for bail without giving specific reasons, citing only fear of destruction of evidence and risk of flight.
初公判後に同様の保釈条件で申請をした際にやっと許可が下りましたが、初公判前後での状況が同じ中で、なんで公判前に許可をされなかったのか違和感が強くあります。
So after the first trial, when I applied for bail once again with the same conditions, it was finally approved. However, as the conditions were the same both before and after the trial, I feel very conflicted as to why this application was not approved before or earlier.
僕は被告人になりましたが、犯罪者ではありません。
I did become a defendant in the case, however, I am not a criminal.
否認をすると拷問のように身体拘束をされ続け、国家権力によりまるで自分が罪人という烙印を押され罰せられているような気持ちでした。
When I denied my guilt, I was detained in a kind of torture and felt as if I was being branded a criminal and punished by state power.
不当な身体拘束の日々は孤独との戦いでした。
The days of this unjust detainment were a struggle against the isolation.
独房の中での生活は自由とは程遠く、心身ともに本当に辛く、トランスジェンダーであることでの苦痛もありました。
Life in solitary confinement, far from being free, was truly painful, both physically and mentally. There was also additional pain caused as a result of my being a transgender person.
この地獄のような日々から一刻も逃れたい。事実とは異なるが、虚偽の自白をすれば、この地獄から出られるのではないか。独房の中で何度も自問自答をしました。
As I was in my cell, I asked myself numerous times, if I want to escape from this hell as soon as possible, perhaps I can get out of this hell by making a false confession, even though it would not be true.
身体拘束は健康面の被害だけではなく、精神面、金銭面ともに影響を及ぼしました。
This detainment caused negative damage or impacts not only on my health, but also impacted my physical health, but also my mental and financial health as well.
僕は支えてくれた人たちがいたからこそ、諦めずに不当な身体拘束をされながらも、否認を続け、諦めずに戦えましたが、不当な身体拘束により心が折れて虚偽の自白をしてしまった被疑者、被告人もいると思います。
Personally, I was able to not give up, to continue to deny my guilt and fight my case despite my unjust detention, because I did have people around me who were in support of me. However, I believe that there are suspects and defendants who have broken down and made false confessions due to this kind of unjust detainment.
被疑者、被告人にも人権があります。日本では否認を続けるほど釈放されにくい傾向にあります。これ以上人権を侵害することがあってはなりません。
Suspects and defendants also have human rights. In Japan, the longer a suspect or a defendant denies their guilt, the more difficult it is for them to be released. We must not allow any further violation of human rights to continue.
失った時間は二度と戻ってきません。僕と同じように人権を、限られた人生を奪われる被疑者、被告人を出さないためにも、人質司法に終止符を打ちたいと思い、原告になりました。
The time that I lost will never be returned. I decided to become a plaintiff in this case because I want to put an end to hostage justice so that no more suspects and defendants will be deprived of their human rights and part of their limited time in life, as I personally experienced.
以上になります。
Thank you.
はい、ありがとうございます。引き続き、質問、we'll open the floor to question and answer. So if you have a question, please give your name and affiliation. Ask one question first of all, and after, if we have time, you can ask more questions. Anybody has a question in the room? If you don't have, I received a lot of a question already online. No? Okay. So I will, we have a lot of questions coming online, so I will ask, first of all, to Mr. Takano. What do you, it's a question coming from Roger Treffler, Asia Times. He's working with Asia Times. So what do you think your chances are to prevail? Watching these cases over the years, it just seems like an exercise of infutility.
はい、ではまずオンラインで届いている質問から入りたいと思います。まずアジアタイムズのロジャー・シュレフラー記者からの質問です。今回で、勝利できるチャンスはどれぐらいあるというふうに思われますが、このような事件を長年見てきていますが、残念ながら、無駄なことのように見えるような状況がありますが、これについてどういうふうに高野先生は思われますでしょうか。
Well, thank you, Roger. Your question is a very tough question, and I expected this question will be put. Well, chance is very, to tell the truth, very small, but that doesn't mean that this litigation is not merit, have no merit. We have a great merit, I believe. And, one of the most kind of a core situation is the general ignorance about hostage justice system in this country. Ordinary people don't understand what's going on in this criminal justice system, especially the detention judgment. And this litigation, I believe there must be other litigation will follow this case, will reveal the reality of the decision making on the side among the Japanese justice system. As I said in my opening statement, that there is a very unfair secrecy of this detention judgment. So almost most people don't understand, don't know this situation itself. So fighting this kind of lawsuit, not just in Tokyo, but in throughout this country, must be very good chance to let ordinary people know what is going on in this country. So I believe this litigation has very huge merit, even though we have a very little chance to win the case itself. Thank you.
関連質問ですけれども、we have another question which is a little bit related to what you said. It is a question coming from Rocky Swift, working with Reuters News. Polls show that the Japanese population support, or at least do not broadly oppose this system. So do you think this is because they ignore how it works? Or is there any other reason?
はい、似たような、関連する質問もたくさんオンラインの方で寄せられていますが、次はロイターズからのロッキー・スウィフトの質問を読み上げます。世論調査などによりますと、日本の市民は今の司法制度を、支持している、少なくとも、大きく反対していないということが世論調査の結果にはなっていますが、その理由はどのようなことが原因にあるというふうに思われますでしょうか。それはやはり知られていないということも関連しているのでしょうか。
Well, thank you, Rocky. I don't understand what polls you mentioned about. I've never heard of the poll about this specific situation of hostage justice system. And I believe at least, considerable or significant parts of Japanese population have a very, strong criticism upon this system. And they feel some shame in comparison with the other countries' detention systems. And now I believe that Japanese, business person, such as manager of the company and the business people, tend to realize what is going on in this hostage justice system. And if your statement about polls is correct, and this is based on specifically the secrecy of the system and less knowledge among the Japanese ordinary people. So this kind of litigation make sense to let the ordinary people know what's going on, and situation will be changed, I believe.
浅沼さん、同じ質問ですけれども、逮捕工作される前にどういった意見だったんですか。日本の司法制度、何か考えたことはありましたか。
And if we can ask the same question to Mr. Asanuma, including also before his arrest, if he did have any particular opinion or thoughts in regards to Japan's hostage justice system and how this may have changed.
もう一回お願いします。
逮捕される前にはこういうことが分かっていたか。
自分が被害者になる前に別に問題ないシステムだと思って、制度だと思ってたのでしょうか、それともすでにやっぱり気になったところがあったのでしょうか。
いい質問ありがとうございます。僕自身は実際に自分が逮捕されるなんて実は思っていませんでした。で、多分多くの方は自分が逮捕されるということすら想定をしていないんじゃないかなというふうに思っています。その中で私はニュースを見ながらそういうこともあるんだ、ひどいなということは認識をしていましたが、そこまで自分の身に起きていることとして考えることは今までしてこなかったので、実際に逮捕されて後にこれが人権の問題だということにすごく自分の中でフォーカスさせて考えるようになりました。
So for me personally, I never even imagined that I would be facing such a situation of being arrested, and this was not something that I had ever anticipated could occur to myself as well. Of course, I saw sometimes in the news similar situations and thought, well, this is quite problematic, but it wasn't something that I had deeply considered really as something that could potentially happen to me as well, and I think that that is the same for the majority of people as well. They would not anticipate that there could be anything directly connected to them, but it was after my arrest that I really came to understand how grave this is as a human rights issue and really fully understand the depth of this problem.
どうぞ。
I'm Yuri Kageyama with the AP. You're the lawyer for Mr. Carlos Ghosn, and I don't know if you're going to get angry with my question, but he was one person who just kind of left, right? And he's still very happily alive. I know that at that time you were not very happy with the way he dealt with his situation, but given that this is a very unfair system, and if you're Carlos Ghosn and you have a way to get into a box and flee, do you now forgive him, or how do you feel?
AP 通信の影山と申します。高野先生はカルロス・ゴーンの弁護士もされていたということで、この質問に少し嫌な気持ちをされるかもしれないんですけれども、当時はですね、ゴーンさんが逃亡した時にかなりその時の状況に対して不満などのご発言があったと思いますが、彼は今海外で幸せに暮らしているというような状況に今はなっています。で、当時の彼の逃亡した行為については良くないというようなこともあったんだけれども、やはり制度そのものが不当であるということに対して、ゴーンさんのように逃亡するようなキャパシティのある人にとって、今彼の行った行為、その状況については今どのように思われますでしょうか。今はそれに対して許しているというような状況でしょうか。
I don't know he's happy now. I don't know, but I'm not in position to comment about whether or not his conduct, his flight from Japanese justice will be, excused or justified. I have no comment about that. But this is one of the very sad story, and this is another point the hostage justice may create. That's my opinion. That's all.
関連ですけれども、悪影響を与えたことなのか、つまりその後の例えば逮捕された外国人、特に外国人は絶対に釈放されないことになったのでしょうか。日本人も含めて。
And I'd like to ask also in connection, do you think that had a negative impact on the system afterwards? For example, it led to other international citizens or who may have been arrested in Japan that they would definitely not be allowed out on bail. Was there any kind of connection or changes after that?
Well, after this episode, the Japanese Justice Ministry proposed a new law amendment which makes some safeguard against flight risks, specifically by the foreign defendants. I don't think this legislation, amendment of the Criminal Procedure Code, I don't think it is clever way of legislation. I cannot imagine other than Mr. Carlos Ghosn who can, hide in
Private
musical instrument box and hire the private jet and go through the security. I don't see any possibility other than ordinary foreign defendant accused. This is useless legislation. And during the several years period after this happening, there seems that Japanese ordinary judges are very reluctant to allow bail, especially for foreign national defendants. But that situation is getting better now. That kind of a return to the ordinary situation now. So, yeah, it has some impact, but it didn't have a, not a great impact at the moment.
I have a question coming from David McNeil, the Irish Times, which is also related to what you said. Is it correct to say that detention periods of criminal suspects in Japan is growing longer? I recently covered the detention of Yukawa Yuji, the head of the Osaka-based Kannama, who was arrested on a series of charges and held for 644 days. There are many similar cases. How significant do you think is Yukawa's not guilty verdict in February? Does it suggest judges are challenging the all-state justice system?
はい、次オンラインでアイリッシュタイムズのデイビッド・マクニール記者からの質問です。日本で容疑者の拘束の期間が長くなってきているということはまず事実かどうかということです。で、最近大阪に拠点を置くカンナマのリーダーであった湯川裕二さんの拘束の取材をしておりましたが、彼は644日間拘束されたというような事件でした。で、似たような事件は他にもたくさんあるというふうに思いますが、2月の湯川さんの無罪判決はどのような意義があるのか、裁判官は今のその司法制度などのシステムそのものに裁判官がチャレンジをしているのか、疑いを持っているのかなどということです。なので、その拘束期間が長くなっているかどうかと、このカンナマのケースで裁判官の最近の変更などがあるかということです。
Well, thank you, David. I don't have statistical data among the period of detention, but I feel the same way which you have. After the amendment about the Criminal Procedure Code and creating the pretrial conference system, if the defendant deny the charge and contest the charge, from time to time the court decided to start the so-called pretrial sessions. And during this session, the defense side can request discovery about the evidences held by the prosecution side, and the prosecution side makes some can have to submit their allegation, detailed allegation, as well as the defense side must file their request of evidences. So, and this pretrial session takes some time. Sometimes it lasts more than a year. And, the case in which one of our client, Mr. Amano's case, his pretrial session lasted more than 2 or 3 years, and during which time he is detained, and his request for bail is denied, and he is still in detention center in Tokyo. So, if you get acquitted, you need to get some, discovery evidences to defend yourself, but it takes some time. So you have a very, serious. You should make very serious choice. So I don't have statistics, but I think this system of pretrial session will make the detention period longer than before, I believe.
Do you think the judges are challenging the system more than in the past?
I don't think so. Japanese judges, specifically in the position in charge of the detention order, are very, similar than before. They denied most of the cases in the bail in which the defendant contest the charge, based on the provisions that Article 89, Section 4, which provide that if there is a reasonable ground of harmful evidence on the part of the defendant, the bail may be denied. And most of the Japanese judges think there is a reasonable ground of harmful evidence if the defendant denied the charge. Very simple.
Any other question in the room? No. So I have other question from Fred Varco, which is a freelance journalist. It's a set of questions about foreign countries condemning or not Japan. So Fred is saying the foreign media in Japan have covered hostage justice extensively, but do you think foreign government and diplomats should be doing more to persuade Japan that the justice system is out of line with Western standards? And do you think that Western countries are happy to condemn third world countries for human rights abuses, but say nothing about Japan's abuses? First of all, these two questions.
はい、次またオンラインでフリーランスのフレッド・バーコ記者からの質問です。日本にある、海外メディアはこの人質司法などを広く報道していますが、もっと海外の政府または外交官の方から日本に対して日本の司法制度が西洋の基準には合っていないということで、もっと働きかけなどをすべきというふうに思われますか。そして2つ目の質問の方が、西洋諸国は例えば途上国などに対して人権侵害などについて批判を喜んでするような状況にはなっていますが、日本における人権侵害については何も言わないということはどのような原因、どのような理由があるというふうに思われますか。
Well, thank you, Fred. Well, first of all, I would like to point out that Japan ratified the International Human Rights Treaty long time ago, and that convention clearly provides that detention must not be rule. It must be an exception for the interest of justice. And Japanese government has a duty to follow, duty to obey these articles, as well as the right of the defendant to be treated as innocent before proven guilty. So it is very simple that the Japanese practice of hostage justice system is a violation of these specific provisions of the international treaty ratified by Japanese government. So, of course, any person, including media persons such as Fred yourself, must have a right to criticize and express the reality in this country. And that is very good for us to end this inhuman system.
日本がサインした証明の中でそれだけじゃなくて、例えば G7 の成果、声明とかをサインしたときに、その内容と実際に起きてることは真逆である時もあるんですけれども、日本の政府は二枚舌ですか？
So not only in relation to international treaties, but for example, things which the Japanese government has signed on in regards to outcome documents from the G7 meetings and so on. It's often the case that the content of what is written in these documents that the Japanese government has signed and what is actually happening in Japan in reality is the complete opposite. So do you think that they are being two-faced in regards to this?
二枚舌って英語でなんて言う
Two faces?
Two tongues? Yes, I agree with you completely. Yeah. And, at the international conference such as Human Rights Committee or some other kind of similar conference, Japanese government simply provide the languages of the law. They don't provide the reality of the system. That is, this kind of attitude irritate the human rights community in especially human rights NGOs and human rights committee based on this treaty. Yeah. So Japanese government should provide a reality, and we should provide this reality to the international world.
例えば外交官、日本にいる大使館とか大使とか、そういう他の外交官向けの説明会とか、そういったイベントはありますか？
Are there, for example, any information sessions or events held to share this information with diplomats or diplomatic representatives, embassies, and so on here in Japan?
I'm not an expert on this kind of international diplomat. Probably Ms. Doi is an expert in this field. Yeah.
And David McNeil, working with the Irish Times, is also asking the role of the Japanese media. They totally ignore some very difficult cases. What is the reason? And do you think that Japanese media should do more on these cases on the system itself?
一つ先ほどのアイリッシュタイムズのマクニール記者からの続きの質問がありました。でこちら先ほどのカンナマのケースに関してなんですけれども、それも含めてこのような難しいような裁判などについて日本の主流メディア、メインストリームメディアをほとんど無視している、報道していないような状況があると思いますが、それはどのような理由があると思いますでしょうか。また日本メディアにももっと監視していくような役割をもっと果たすべきなのかという質問です。
Well, I agree with you. And Japanese media don't provide basic information about the hostage justice system, as well as criminal case generally. And that's based on the probably I think. It is based on the lack of information. And Japanese media cannot access to the criminal investigation file. They don't have any access to the evidences held by the public prosecutors. They simply get information through the police officers and public prosecutors. So their information is very one-sided. It's not fair, but this is a reality. Japanese media cannot get, full information about the criminal case. And after the litigation of 2004, some 20 years ago, which provided some restriction upon the defense side. Now, the defense counsel cannot provide the copy of the evidences to anybody, including media people, got from the public prosecutor through the discovery system. If, for instance, if I provide you the copy of the evidences of the Carlos Ghosn case, I could be criminally prosecuted and get punishment, including imprisonment. So this is another situation, another reality that prevent mass media people ignorant about criminal justice in this country.
ただ例えばフランスでも弁護人がその証拠をマスコミに出すと、それも違法ですが、ただそれでも弁護人がすごくマスコミに出て説明するんです。自分のクライアントをものすごい守ってるんですけれども、日本の場合は高野は例外、高野さんが例外だと思うんですけれども、ほとんどの弁護人はマスコミに話さないんです。結果的に一方的な情報しかない。しかも誰かが逮捕されるときにマスコミも呼ばれてるんです。それは一番ショックを受けたことを私日本に来たときに、フランスとかでは誰かが逮捕されたときにその映像はテレビに出ないんです。推定無罪もあるし、あとはマスコミが呼ばれてないことです。なんで日本でそういうことはいまだに起きてるか。マスコミは犯人とは言わない、容疑者と言ってても、でもその人の顔をもうテレビに出すと、容疑者と言っても、犯人の姿をそのまま、その段階で作ってしまうんじゃないかと思います。どうですか？In
the case of France, it is also illegal for lawyers to share information and evidence on directly with the media. However, at the same time, lawyers are very proactive in going out and speaking to the media and making explanations and so on in behalf of their clients. While Mr. Takano is perhaps an exception to this, almost all lawyers in Japan are not willing to speak at all to the media, and this is perhaps leading partly also to some of this one-sided information, which is the only information available to the media. Another aspect is when an arrest takes place in Japan, the media is already present on site at the place where the arrest is actually happening. This was the part that was most shocking to me when I saw this happening in Japan as well. You would never in France, for example, see footage of the actual moment of the arrest on the television, on the media as well. First of all, the media would not be informed by the police, first of all, that the arrest is going to be taking place then, as the first reason. And the second also, despite the fact that they may be using the word suspect to refer to the individual who is being arrested, but by showing their face and name and so on television, even if they are being referred to as a suspect, they are creating a visual and an image of them as a criminal in this case. So this was something very shocking to me when I saw this occurring in Japan. What is your comment in regards to this?
Well, I'm not an exception, I think. This is a very rare case. I'm showing to the media. This is a very rare case, even for me. And, because the criminal defense lawyer is very busy to, and we have a duty to be, confidentiality and to our client. So it is not easy for defense lawyer to reveal evidence or tell the story about their client. It is very risky and must be restrained and must be, very rare. Yeah. So that's my opinion. And the basic point is the secrecy of the process. Again, the Japanese police officer ordinarily show the suspect arrested to the media, and they have some, silent agreement between police officers and media people. And that's why media people can occupy the very good place to shot the suspect's face in front of the police station. And the police officer is very cooperative to make them very good shot of the faces.
はい、どうぞ。
My name is Takuya Nishimura, freelance journalist. Let me ask in Japanese. 日本語で伺います。現実には人質司法というものが行われている中で、真犯人を捕まえるということにつながったケースがきっとあるのではないかと、その成功体験がなくならない原因の一つではないかと思うんですけれども、人質司法を全面的に禁止すると、そういった事件を解決するということも難しくなるかもしれない。そのために人質司法なしに事件を解決するための代替的なアルタナティブウェイというのはどういうものなのかご説明いただくと。
I'm a freelancer. My name is Nishimura. In reality, perhaps one of the reasons that there is an ongoing situation of hostage justice in Japan is that perhaps this system or this kind of process can sometimes contribute to actually resolving a case through identifying who the actual criminal, the actual person responsible for a case is, indeed through this kind of process. So this may be one of the reasons why the Japanese judiciary is reluctant to change this system or to make any changes in this. Therefore, if the hostage justice system is indeed fully abolished, what kind of alternative methods, alternative ways could be put in place by the prosecutors and so on to ensure that indeed the actual or the person responsible for the crime can be accurately identified?
Thank you for that question. A very, very unique question. I've never thought of that. Well, the hostage justice is unfair. Not just for the innocent people, but for guilty people. Guilty people have a right to be treated innocent until proven guilty at the fair trial. That is a constitutional guarantee. So, in this hostage justice system, the individual who denied a charge will be detained very lengthy period. That's a huge pressure upon individual to confess or admit a charge. Even innocent people would admit a charge. That's a problem. Okay, and there is no clear line between innocent and guilty people to be fined through this system. And we have, we other, member state of the International Human Rights Treaty must follow the fair trial or fair detention system. And through this fair system, we should find out guilty people to be punished. That's the only way. There's no alternative way, I think.
I have another question online. It's Fred Varco, once again, a freelance journalist. What immediate changes would you like to see in this justice system?
もう一つフリーランスのフレッド・バーコーさんからの質問です。すぐに日本の司法制度の中でどのような変化を求めますか、どのような変化をすぐにできるものとしてあるべきだと思いますでしょうか。
Well, what we can seek, through our day-to-day practice is to is for the judge to apply the law as which says. I mean that judge must follow the language literally. The Article 89, Section 4 said, the defendant shall be granted bail unless there is reasonable ground on the part of the defendant to hamper evidence. Hamper evidence is a very unusual or stuff. Just denying the charge is not the hamper evidence. So simple. So if the judge follow the languages of these provision strictly, it is very hard to prove the reasonable ground to stop the bail. But as a matter of fact, as I said again and again, there is a secret information shared by judge and prosecutor. We cannot access to this information. So they understand each other. In this case, there is a reasonable ground. But we cannot, see what is really, concrete, fair, concrete ground of the hamper evidence. We don't know what they think about it. They don't explain in their judgment, which they deny the bail. They simply check the, number 4 of the Article 89 or something like that. And even the appeal court, they don't explain very concretely about what is they believe reasonable ground. They simply, based on the attitude of the defendant and the nature of the case and statement by the co-defendant, there is some reasonable ground on the part of defendant to hamper evidence. So nobody understands what is the reality of this basis of this reasonable ground. So I immediately hope the situation must be changed simply following the languages and explain clearly what kind of elements or what kind of facts make the reasonable ground.
もうすぐ、時間ですけれども、浅沼さんに質問したいことあるんですけれども、それは、拘束された時にその待遇、もう少し詳しいことを教えていただけますか。最後の質問に関連性のあるので、最初はその状況の説明いただけますでしょうか。
So I'd also like to ask, we don't have too much remaining time, but I'd like to ask Mr. Asanuma if you could share a little bit about what kind of treatment you experienced when you were being detained. And this is connected to the final question, which has been shared online.
質問ありがとうございます。各交流の施設によって多分その判断が違うんでしょうけども、私の場合はもともとは生物学的には女性で戸籍変更して男性だということだったので、男性の方の収容の方に入ってたんですけども、そこでもやはりその逮捕された段階で身体検査があるんです。で、日本の場合戸籍を変更したとしても、私の場合は身体的には女性に近いような体だったので、そこでまずはチェックをされるという苦痛があったりとかですね。で、中に入ったとしても、他の被疑者被告人には知られたくないという部分があったので、看守には秘密にしたいっていうことは最初の方には言ってたんですけども、アウティングをされてトランスジェンダーが入ってるっていうことを言われてしまって、そこから他の、独房にいたんですけど、隣の被疑者とかに、女性が入ってるみたいなことをちょっとおちょくられたりとかした経験もあったりとか、あとは看守もトランスジェンダーという知識がないので、 女性として女性が好きなのかみたいなこの差別的な発言を受けたりとかという言動的な発言での、こう嫌がらせみたいなこともあったんですけども、他にもその健康面で、僕自身はそのホルモン療法を打ちたいということを話して、検討しますということで言われて打てたんですけども、結局はただ、ケースによってはトランスジェンダーで打てなかったというような、ケースを聞いたりとかしていたりとかして、各その施設の判断になってしまう。あとその、起訴されてから拘置所に移動しなければいけないんですけども、拘置所が満員ということで僕は留置所にずっといました。で歯が痛くて虫歯だったんですけども、治療したいっていうことを話したんですけども、拘置所であれば虫歯治療はできるけども、留置所にいる場合だと虫歯治療はできないと、緊急的な痛み止めを飲んだりとか、あとは歯を抜くというような治療しかできませんというふうに言われてしまって、歯を抜くのはすごい重大なことなので、私は痛み止めをずっと飲みながら我慢をしてたんですけども、そういった被害とかもありました。あとはお腹が痛いといった時にも具体的な大きな病院で検査をするということはできなかったので、看守が持っている緊急の内服薬で対応するというようなケースなどもあって、なかなかその健康面でもきちんとしたフォローっていうのはしてもらえなかったです。あと精神面もそうですけども、ご存知でしょうけども、留置所にいるとトイレ、そしてお風呂全部監視をされます。自由はありません。何かしたい時にも監視に言わなければいけないような現状です。そんな中で私は特に苦痛を感じておりまして、メンタルが不安定になっていたんですけども、そういったフォローは一切されない状況なので、一人で戦っていくというような状況でありました。
So first of all, the different situation of treatment is largely left up to the judgment of the particular facility. So depending on where you are being held, what kind of facility that is, and the individual facility will mean that the treatment will be quite different. In my personal case, when I was born, my declared sex was as a woman. I then went through and changed on my koseki, the Japanese registration, and so on to be registered as a man. So I was first of all held in a facility for men. However, at the time of being arrested there is a physical examination which everybody has to go through when you're being held into the detention center. While I am legally a man registered within the koseki, within the family registration in Japan as a man as well, physically some of my characteristics are closer to being the sex of a woman as well. So therefore this physical examination and the process that I went through in regards to this caused great suffering or difficulty in regards to that. Also, when I was being held within the facility as well, at first I indicated to the guards that I did not want it known that I was a transgender person to the other people who were being detained at the facility as well, and I made this request. However, I was forcibly outed by the guards as well, which meant that there were also words from other people being detained there saying, oh, there's a transgender person here now. I was being held in solitary confinement, but there was, for example, the person held in a neighboring cell I would hear them saying, oh, there's a woman in here now, for example. And there was also discriminatory words or treatment from the guards as well because of their lack of knowledge or understanding in regards to transgender people and transgender issues as well, saying, oh, you're a girl and you like girls, right? Or these kinds of things as well. There was also various health impacts as a result of my treatment as well. For example, I'm usually going through hormone treatment as well, and when I made a request to continue this treatment, this was first of all said that it would be considered. Eventually, I was allowed to continue my treatment, but I have heard of many other cases of transgender people in detention facilities who are not able to continue their hormone treatment, for example, when they are being held as well. When I was first out, because there was no space within the prison facility as well, I was first held in a detention center, and there, as you can know, the situation of the treatment there is quite limited as well. For example, after the indictment, when I was being held there, I had a sore tooth for a while. But however, when you're just in the detention center there, you're not able to receive dental services as well. It is only in emergency cases they would just remove your tooth, for example, or give you emergency painkillers as a medication. However, because I was not able to actually see a dentist or have treatment, I felt it would be too extreme just to remove the tooth. Therefore, I somehow put up with this pain just with the painkillers that I was being helped, but with no other dental treatment being able to be provided as well. There is also the situation of when I had a stomach ache, for example, not being able to be held for a test actually in a hospital, but just to have to deal with the sort of very limited first aid that they were able to provide there as well. So it's only the real first aid emergency treatment which is able to be provided within these kind of detention facilities. Also psychologically, there was a great amount of suffering or as a result of the treatment I went there as well. As you're aware, in these kind of detention centers, you are under constant watch, under constant monitoring, even when you're going to use the toilet, going to the bathroom and so on as well. You have to ask the guard for permission, and then you're under monitoring for all of this as well. And this led, in my particular case as well, especially to mental anguish and very unstable situation as well. However, there was no kind of psychological care provided for this as well. I had to just deal with this kind of situation and the treatment alone.
どうもありがとうございます。最後の質問。It will be the last question, but it is related to this one. I will ask to Mr. Takano. Do you think that the system used by the prosecutor to keep a suspect in custody is entirely different from the Japanese prison system? Because he visited the future prison, and the head of the prison said that it's no bad treatment in the prison. So, what do you think that the pre-trial detention and post-trial detention is different?
Yes, it is completely different system. The future prison is a place for the person who already convicted and serving their term, and they have a based on their rank and designation, they have access to their family, and they can exchange the correspondence with some person. And if you serve, very good time, those opportunities are getting expanded. On the other hand, in pre-trial or during trial session, the detainees from time to time ban to communicate with other people than their defense counsel. This is very ordinary situation that detainee cannot meet with his or her spouses, friends, and relatives. They just meet their attorneys. Attorney, cannot visit their client every day. Sometimes, So this is completely different system between, penitentiary and detention.
ありがとうございました。So this is the end of this press conference. I would like to thank very much Mr. Takano, Mr. Asanuma, and I will give you 1 year membership to this club, so you can come when you want, have a discussion.
I have to pay the membership?
And you can discuss with all journalists in the bar and so on.
Thank you very much.
Please come.
Thank you.
1年間の会員長です。はい。
Thank you very much.
ありがとうございました。
ありがとうございました。
Thanks so much.